Hello everybody, a very warm welcome to all of you. Today we would be discussing a very basic concept of CPC which I would name as a backbone of the entire civil suit. Why do I call it a backbone? The reason behind it that it is the one thing with the help of which the proceedings are in fact initiated in the court of law. In a criminal case, if the proceedings initiate from filing of a complaint or from the registration of FIR, in the civil suit, the proceedings initiate with the help of the pleadings. Now, what are the meaning of the pleadings? What are the rules required to be followed while drafting a pleading? When can pleading be amended? Why do court allow amendment of pleadings? What can be amended in pleading? And a lot of criticism is being faced by Order 6 Rule 17, that is amendment of pleading, as to why. And what happens when an applicant fails to amend the pleadings in a prescribed time given by the court. Now, all these issues we would be discussing in the later course of our discussion. But to start with, the meaning of pleading has been defined under Order 6 Rule 1, which simply says that it shall be plain and written statement. Now, what is plain? It has not been defined anywhere. What is written statement? It has been defined under Order 8 Rule 1. So, the pleadings general meaning is that a statement of fact which are submitted to the court or filed before the court, just with the request that court should adjudicate upon it and grant a relief if one is entitled to in his favor. Now, there are certain rules which one is required to follow, because we are not telling a story to the court and we are bound with certain principles and certain parameters which we have to keep in view while drafting the complaint. Of course, by keeping in view the dignity of the court and the precious time of the court should not be wasted. Number of other factors which you have to keep in mind while drafting the pleadings. But at the same time, the pleading should be so concise, clear, specific, that it should not discuss the law, because law is one thing which is to be taken care of by court itself. This is the forte or the domain of the court, and the court is powersome to look into it. So, the basic principle which you have to keep in mind, that plead fact, not law. Fine. So, always whenever you draft a plaint, or we take an example like, from that example I think I would be able to clarify it in a very clear manner, clear way to you. Suppose there is an agreement between A and B, selling of some property, and A is a vendor, B is a vendee. A has already received a consideration, but now is not fulfilling his part of the contract, not coming forward. B is an aggrieved party who has already paid the earnest money, now ready and willing to get the sale deed executed, but still the A is not coming forward, and A failed to return. B issued a legal notice also through his counsel, but still is not coming forward. Now, what he has a remedy to go to the court of law and make a request to direct the A to get the contract specifically enforced. Now, my dear friends, here you need to understand 2-3 things very clearly. Now, when you are to plead a fact before the court, you have to have knowledge of the substantive law first, which actually explain about your rights and obligations. Now, here in the example I quoted, a person who is going to draft a plaint, he should know first and foremost the law of specific performance. I mean, he should be well aware with the Specific Performance Act. Then he should be aware with the Transfer of Property Act as well. He should be aware with the Contract Act, because it emerges out of the contractual obligations, so he must know about the Contract Act. He must be aware with the Limitation Act, because the suit has to be within the limitation. He must be aware with the Court Fee Act as well, because he ultimately has to evaluate the subject matter and decide the court fee on it. Fine. Then he must know the jurisdiction part, the place of suing as provided under CPC. See, my point here to explain you that substantive law comes first, then the procedural law. And if you, being a counsel, are advising your client, then if you have a knowledge about all these laws, then I think you would be able to satisfy him, and he would be happily engaging your services. So, those who are in practice, they need to understand as to what is the importance of substantive law, and when they need to know about the procedural aspects as well. So, the rule of the pleading, it simply says that precise, concise, clear, not ambiguous, not vague facts should bring before the court. So that one reason is that the precious time of the court should not be wasted, and one should remain to the confined to the issue which is to be determined by the court. So if the issue is not clear, then judgment would be very vague, and ultimately the whole exercise would turn out to be futile. So my dear friends, you have to be very, very careful here. Material fact are to be pleaded. Immaterial and irrelevant fact have no place. And yet another reason which is very important to my mind is that the court, the basic principle of law is the court cannot go beyond pleadings. So now if you are not mentioning the facts of the court properly, the issues are not being framed properly, and you are expecting a decision of the court on certain issue which has not been pleaded, then it would be very hard and difficult. Even if such a decision is given, it would be challenged and it will not sustain under the law. So my dear friends, you need to be very, very particular when you have been. Now, plaint is something which is filed by the plaintiff, and the written statement is something which is filed by the defendant. Now, plaint and written statement both are called the pleadings. And the moment plaint is instituted in the court of law, it is numbered, it becomes a suit. Otherwise, suit has not been defined under CPC. Now, we have already discussed in the last lecture when I explained you the decree, order and judgment, that a decree is ultimately to be drawn from the suit, not from the application or the petition. So, if you really want that court should give you, some kind of relief by way of decree, then you need to institute a plaint, which would ultimately turn out to be a suit. Now, law is not to be pleaded. Evidence should not be given in the pleading also. Fine. Although, in order to support your case, you can provide a list of the document, but it should not be by way of evidence. Now, these are some rules which have been provided under Order 6, Rule 1 to 13. Now I come to the very crucial aspect which is called amendment of pleading. What is the object of the amendment of pleading? See, to err is a human, we all know. The basic object, primary object is to secure the end of justice, to prevent the injustice. Now, as I said earlier, the basic question before the court is to decide the matter in the controversy. So when the court is not able to know or not able to determine the real question of controversy, then there would be no scope for proceeding further. So to determine the real question of controversy is the main thing. It could be left by the parties to be pleaded by mistake, or otherwise it was not in their knowledge. There could be many reasons. Then court used to amend the pleadings liberally in order to subserve the cause of justice. But now the trend is changing, because 80% of the case, it has been seen, are filed just to prolong the litigation or to cause harassment to each other. Now, to discourage people who comes with this kind of mindset, the Supreme Court time and again have issued number of guidelines that wherein it is found that there is a malafighting intention, or it has been only filed with the purpose of causing the delay or to cause prejudice or the harassment to the other party, then it should not be allowed to be amended at all. Fine. So, the objective is to determine the real question of controversy, to correct the mistakes in the pleading, or to protect the right of the party and not to punish them. If they made a mistake, they should be given a chance liberally. Maybe it could be subject to cost also. They should be given a chance to correct or rectify it. Right? So, one more important thing which you will have to understand is the concept of relating back theory. Now, what does it say? The moment the application for the amendment of pleading is allowed, it relates back to the date of institution of the suit and not from the date when it is allowed. So, this is very important. You could be asked in your preliminary exam, you should be aware as to where this concept is and what does it mean. So, the moment it is allowed, it will go relate back to the institution of the suit, so that one should not be subjected to face the limitations and all. Now, let's come to the Order 6. Let's read it in order to understand it further. It talks about two things. First, that at any stage, court may allow or alter or amend on such terms as may be just, one, as may be necessary for the purpose of determining the real question of controversy. There is a proviso which is very important, which says that no amendment after the commencement unless the court comes to the conclusion that in spite of due diligence, party could not have raised the matter before commencement of trial. Now, two words have been used. One is may, which is discretionary, shall, which is obligatory. Now, proviso say that once the trial begins or the commencement of trial starts, then the party would not be allowed to amend the pleadings generally. But in case court comes to the conclusion that despite of the due diligence, party could not have raised the matter before commencement of trial, then it would be allowed. Now, meaning thereby The word due diligence is very important, that one has taken a due care and caution before filing. The facts somehow which were not in his knowledge, he could not plead at time. Now the court has come to the conclusion that yes, in fact these facts were not in the knowledge of the concerned party, the party should be allowed to give. Fine. So here three words, may, shall and the third one is the due diligence. You must know as to what is the significance of these three words. Now the time and again courts have propounded that wherein amendment is such which are going to change the basic nature of the suit, it should not be allowed. Then it says that when it is leading to a fresh cause of action, fine, then it should not be allowed. When it is going to cause prejudice or going to cause deliberate delay, then it should not be allowed. And when altogether a new case is going to be set up by a party concerned, then it should not be allowed. But where it should be granted liberally, the court further held that to avoid the multiplicity of the suit, or if something has been wrongly described, to rectify, to correct or to add or to alter or to modify, then it should be allowed. Now if the court prescribed the time while allowing the amendment of the pleading that you have to amend it plaint within the 7 days or 10 days, then it is okay. One is supposed to follow it. But otherwise, if no time frame is prescribed, then it would be constituted to be taken as 14 days from the date of the order. The 14 days period, or if in case Order 6 Rule 18 makes it very clear that if amended plaint is not filed despite of the grant by the court, then ultimately he would be barred. One would be barred to file within the prescribed time. If one is failed to, then it would be barred by the court. I have evolved my own definition of plaint. If you like it, you can remember it. This is a concise statement of fact, set forth cause of action along with a prayer of relief. Now the plaint is the concise statement of fact which set forth the cause of action along with the prayer of relief. And the cause of action is a very important term, like the whole the proceedings and the process evolve around the cause of action only. So whenever you have to mention the fact which led to cause of action, you need to make one paragraph for that as to how the cause of action occurred to you, on which the court should now adjudicate, and it is within the competent jurisdiction of the court, and the court has every right to try the suit. This is what you require to mention in the plaint itself. Now see, the reason of stating these facts is that you are making your opponent aware also, fine, in order to make him prepare for the defense, and you are at the same time disclosing the agony, the agony or the anxiety or the grievance to the court by way of fact which has led ultimately to the cause of action. So my dear friends, all the students or the persons who are practicing law, they must know that the importance and significance of the substantive law and procedural law is equally important, and one should not forget that it is the basic thing which from where you should have to have a authority or a command. And I think once you have the command on the pleadings and you know the importance of the substantive and procedural aspect, then you would be able to convince your client more effectively. Fine. I think it is enough for today. See you in the next lecture. I hope I have been able to clarify. Bye.